Дякую. Всім доброго дня. Раді вас вітати сьогодні на нашому заході. І певними технічними проблемами з затримками, але ми все ж таки розпочинаємо. І сьогодні поговоримо про досить важливу тему в контексті подій в Україні. Це безпосередньо як документування воєнних злочинів, які вчиняються на території України, так і про механізми, які можливі для того, щоб притягнути до відповідальності тих осіб, які відповідальні за те все, що ми сьогодні відчуваємо в Україні, бачимо з-за кордону, і те, про що пишуть зараз скрізь і всюди. Тому я пропоную почати сьогодні з того, щоб поговорити про те, яким чином, що можна зробити для того, щоб притягнути до відповідальності людей, які роблять ті речі, про які навіть страшно було подумати українцям ще до 2014 року. А після 24 лютого ми отримали ще більш масштабні дії, ще більш криваві і жахливіші. І географія цих подій змінилася. Тепер немає жодного захищеного місця в Україні від найпівденнішої точки України до найпівнічнішої, найсхіднішої до найзахіднішої. Як ви можете побачити, події відбуваються в кожному регіоні України, а інколи наслідки цих подій стосуються і інших держав, таких як Молдова, таких як Польща, і це яскравий показник цьому. Я пропоную приєднати наших спікерів, які є в онлайні, і я хочу представити...
So the suggestion now is to switch on the online speakers and go ahead. Я перекладатиму послідовно.
Дякую. Марія Мезенцева.
Ні, давайте.
Прошу.
Yuriy Mezentseva, who is MP and chairperson of the Ukrainian delegation to the Parliamentary Assembly of the Council of Europe. She has to be online with us. Yes, there she is.
Yes, hello, friends.
Марія, передаємо слово вам. Просимо вас поділитися вашими очікуваннями і баченнями від того, що Україна може зробити і що для цього нам потрібно, для того, щоб притягнути до відповідальності.
So we pass on the word to Maria and ask her to share her expectations, what the Ukraine is going to see in the nearest future.
Thank you, dear friends. Sorry for circumstances I'm in. We just have a voting day today. Therefore, I will try to be very short and very particular in my comments.
We won't be translating into Ukrainian.
Okay, super, great. I will go on with English. Great, thank you. We'll save some time for other speakers. As of the 24th of February, parliamentarians in all Ukraine has been witnessing numerous war crimes. Today we have several working groups with this regard. There was a special investigative group created in the Parliament of Ukraine, which is linked directly to war crimes and to possible proposals to law and amending the criminal code of Ukraine and other important laws in terms of bringing the perpetrators of the war crimes to justice as soon as possible. For this purpose, special, as I said, special working group was set up, and now I will be walking. Sorry for this. A special working group was set up, and it comprises of MPs from all the fractions. Not only that is functioning currently, but that made us visit, for instance, a spot where war criminals who are current Russian prisoners of war are being are being concentrated for the purpose of exchanging them for our heroes. And as you know, unfortunately, ICRC, International Red Cross, is not taking active part in it. And moreover, we see the breaches on the Russian side of the Geneva Conventions constantly, which are also war crimes. So before the 24th of February, of course, the current year, of course, the war crimes existed, but not in that numerous spectrum. We receive daily updates from the Prosecutor General Office. And as to my knowledge, the recent number of the war crimes registered in Ukraine is now more than 62,000. 62,000 in terms of something that touches upon every Ukrainian family. Today, we're talking about the ruined buildings, the ruined houses, ruined property, burned to the ground, civilian infrastructure, hospital, maternity leaves. I can tell you honestly, I haven't registered my building, which was bombed numerously by the cassette rocket bombs from the Russian criminals. What we're trying to do at the spectrum of international law to make this war crimes being widely heard, B, being investigated, and C, being recorded properly, because what we have learned from recently, people still, postpone the registry of such war crimes, thinking that they, that it's not very important. It is. That's why, as politicians, we try to explain in the constituencies, in the regions, in the newly liberated territories, even the crimes of tortures and the crimes of rape, which are all fall under the umbrella of the war crimes. We're trying to help with authorities of the national police, of the prosecutor's office of the region, to make a record of such cases. And of course, if victims need psychological support, to provide it to them as soon as possible, according to the existing international programs and national programs of psychological support. I would like to make one point on on our activities in the Council of Europe Parliamentary Assembly, where we were extremely active and I think effective since already the 12th of March, where we pushed forward a text of the resolution which was voted, if I'm not mistaken, on the 13th of March, kicking out Russia from this institution, which deals mainly with human rights protection. And on a very high level, on a very top level, we are committed to, in numerous later on resolutions of the Parliamentary Assembly, talking directly who committed these crimes. Obviously, the soldiers of the Russian Federation Army. We were talking about also the crimes which are linked to forcible disappearance, especially children. And I think there is a new idea of putting forward either a written declaration or even a resolution with regards to the missing children, which are amounted to around 300,000 approximately right now, and around 1 million in total of forcibly displaced persons from February 24th, and of course forcible passportization, filtration camps, missing persons. All that falls in our other dimension of working with authorities on Ukrainian side. Colleagues, interesting things are happening under the umbrella of ICC, International Criminal Court, the colleagues of which are helping us to investigate, of course, war crimes, the crimes of genocide. At the very beginning, when the understanding that before all these war crimes, there was one mother crime of all, a crime of aggression. And if that wouldn't happen, we wouldn't witness that many investigations of the war crimes today. Our colleagues from ICC wanted to discuss the mandate of the institution to possibly broaden it up a little bit, to insert the crime of aggression, which is Fortunately or unfortunately impossible, because Russia as a state will never ratify a Rome Statute, and we are really at the historical crossroads of the international law. That's why let me touch a little bit upon our promotion of creating ad hoc tribunal for the crime of aggression, and of course continue to be committed as a state, as parliamentarians, as the Prosecutor General Office presented in all the regions of Ukraine. And by the way, Mr. Kostin visited and had meetings with top officials of the court, of course, and of the Council of Europe on the ground in Strasbourg. We are committed to the existing institutions, and we don't want to downplay them whatsoever. But the importance of the investigation, the facilities we have, the international community which sent us, I think first was France to send us experts on the war crimes to join our international investigative team. That we highly appreciate, and we want to see more colleagues who are doing that. And that we do during our that we will do during our future tour on supporting tribunal, but also talking about the war crimes and what exactly we need in this particular moment. We're linking these needs and needed items directly from the Prosecutor General Office, so we're not making it up ourselves. Colleagues, probably these are the main points I wanted to raise on the side of the Council of Europe activities, but I think that the work which is conducted here in Ukraine is extremely important on a day-to-day basis. In my home region, Kharkiv, we are already making sort of, a park of missiles collected since the 24th of February up until today, and it becomes bigger and bigger every day. We do hope that international law can be repacked and relaunched. And something we've been reading and learning with you in the books would work with some extra spices of this brutal and unneeded war, which Ukraine and the all civilized world will definitely win. Thank you so much for this opportunity, friends.
Дякую, Юлія. Ми вдячні вам за вашу участь, ми вдячні вам за ту роботу, яку ви здійснюєте зараз на міжнародній арені.
We're grateful for your participation and for the work that you are doing on the international scene.
І надіємося, що все ж таки Україна скоро переможе, і ми зможемо дійсно подавати цю юридичну, в тому числі, проблему, щоб притягнути до відповідальності.
And we hope that Ukraine will win soon and we will be able to overcome this problem in order to bring the culprits to justice.
Ще раз дякуємо і
Thank you, colleagues. Just one last point, sorry, I forgot. Many lawyers were saying that it will not be possible to call the Russian regime a terrorist regime. And look, each next attack, there are more countries who are joining our initiative in the Council of Europe on a broader spectrum. And we have to call the state who they are. They are a state of a terrorist regime. Thank you so much again. I run. I wish you a fruitful discussion.
So I've been told that there is English translation available now. So please use channel 1, I guess. Yes, channel 1 on your headsets for the English translation.
Дякую вам за допомогу і продовжимо нашу дискусію. В зв'язку з технічними проблемами вимушені певним чином трішки змінювати черговість наших спікерів. Це все пов'язано безпосередньо з тим, ви самі бачили, як безпосередньо у нас почався сьогоднішній ранок, тобто і на 40 хвилин запізнення. Тому надалі я, напевно, попрошу тоді Олександра Миколайовича, виконавчого директора Української Гельсінської спілки з прав людини, продовжити нашу сьогоднішню дискусію.
Dear colleagues, I see here many familiar faces who are dealing with this issue, the and accountability, and I thank you for joining us for this panel. And I will starting with several points that, as to me, are very serious, and probably they should be considered as the main tasks for the whole process. First issue, the political and judicial approach to the process of accountability. The tribunal that should be organized is a purely judicial structure, but all the solution should be taken on political level. And creation and the mandate and the jurisdiction of this instrument of accountability depends on the political level. And the measurement between judicial and political content in this process is very, very important. And Madame Mezentseva stressed that now we have the forces and the processes on political level, on European level, on the level of the Council of Europe, European Union, but the support for this process on global level, I mean on level of United Nations organization, is required. And we see even yesterday example that no efficient international mechanism of stopping aggression acts in today's war exists. So the protection mechanism should be established to have such efficient instrument of responsibility through the accountability. And here we have, and our mission is to involve the politicians, the actors and key players on international level into this process, and to create a milieu, as it was said yesterday, that will require the establishment of such institution. Yes, we have now ICC, but I may remind you that even a year ago we have Minsk agreement process that now is zero. And when we tried to find solution how to get back the territories of Crimea and Donetsk, Lugansk regions, well, the indication was, see the Minsk process. Well, it's the something that now existing. So we have to have the open mind, and we have to appreciate the current situation and understand that we need the concrete and effective mechanism on accountability. And this mechanism should be strongly supported on political level and very professionally organized on judicial level. And we are ready for that. We have numerous cases registered in the different databases like War Crime UA that is related to the open criminal proceedings on national level, and today's statistics is 46,888 cases, and the three articles, main articles of the violation of rules of the war, 438, 437, and 436. I will not explain in details what does it mean, but in generally it's war crimes, crimes against humanity, and genocide crime. We were asked yesterday about the genocide crimes and investigation of genocide crimes. We will speak about it a little bit later, but the issue how to bring the perpetrators in genocide crimes to the justice is crucial, and we have to firstly find the scale and describe the situation as systematic and mass organized crimes like politics, and here politics by the aggressor, and here I have to refer to another one point. We have almost forgotten what was done before 24th of February of this year, but the same war crimes were occurred, dozens, hundreds, and thousands, and we have not lost them and forget them. Volodymyr Rybak, it was March 24. The same that was done in Bucha in the February of this year, 8 years later. This student Popravka killed at the same time. Stepan Chubenko. We know even the names of the killer of this war war crime perpetrators. This evil was not punished. And we have to include it in this statistic, because this statistic started since 24th of February. The number is not 46,000 with the 888. It's much higher. And second issue, we have to resolve two very important questions. A, we may register, we may find even the legal proofs for such, forever such case. But how can we assume that all these cases will be properly investigated and be on judicial level resolved with the proper verdicts, and all who was considered as perpetrator will be punished? This scheme should be established, and this scheme might not be established on the ICC level. Sorry, it's not the criticism to ICC, but we see the situation in a realistic vision. A. B. It should be instrument that should be developed, and when we proclaim that all the perpetrators should be punished, well, probably we have to think what we consider under the meaning all, and how we will realize this goal. It's B. Then I will finish now with the our current work results. I mean, we are the initiatives of NGO organization that dealing with the documentation with the two tasks. Firstly, to find as much as possible factual information on the occurred crimes with the all possible legal proofs on the situation, and we try to use the documentation process not only to fix the facts, but also to receive additional information from the first hands, and to present the picture at the systematic towards several and special types of crime, like tortures, like forced disappearance, like rapes. I may later tell about these GBV cases and why they are so invisible in Ukraine and difficult to detect, and relatively it's almost impossible to mitigate. I will finish with just last probably unknown for you facts. In our discussion with the Deputy Minister of Interior, she said me that it was just chance and happy occasion that the victim of rape find in the interview, video interview with one of the POW Russia, that he exactly was a perpetrator, and he was now on Ukrainian territory in jail. So it was lucky chance that the investigators have found the alleged perpetrator, but it was almost single case of such type. So we have to think how we may introduce the system that such cases will be regular, and we may assume that the perpetrators will be found and punished properly through judicial means. Thank you.
Дякую, Олександре Миколайовичу, за окреслену рамку. Ті важливі речі, які ви підняли в своєму виступі. І я пропоную безпосередньо в такій же черговості і йти в наших подальших виступах наших спікерів. І думаю, що почнемо ми безпосередньо з механізму міжнародного, того, який не лише Міжнародний кримінальний суд, а і безпосередньо інші можливі міжнародні механізми, які ми можемо застосувати. І я б хотів би передати слово Антону Корynевичу, який, я надіюся, вже підключився до нашого заходу. Антон є послом з особливих доручень Міністерства закордонних справ України. І він якраз є безпосередньо тим, хто може нам найбільш, напевно, детально і професійно розповісти про те, що відбувається на сьогоднішній день у нас на цій ниві, і що ми можемо з цим зробити. Антоне, чи чуєте ви нас?
Good morning from New York. Yes, I do hear you well. So if you don't mind, I may start. Yeah. Whether you can hear me well, colleagues?
Yes.
Okay. So first of all, of course, I would like to thank the organizers of the event to have this possibility to talk on such an authoritative forum, international conference, and to dedicate several minutes of my speech towards the issue of establishing and the need to establish the special tribunal for the crime of aggression against Ukraine. Well, I'm sure that both Ms. Maria Mezentseva and Mr. Oleksandr Pavlichenko, they were speaking about the fact that the issues of accountability are of primary importance. And we cannot speak and think about reaching peace without reaching justice. And justice and accountability should be an integral part of the finishing of the end of this armed conflict, which was caused by the aggression of the Russian Federation against Ukraine. And of course, all those persons who committed mass atrocity crimes, war crimes, crimes against humanity, crime of genocide, other war-related crimes, of course, they must be brought to accountability, either through the means of national judicial system of Ukraine, in the result of work of Ukrainian law enforcement agencies, Ukrainian Prosecutor's General's Office and regional prosecutors' offices, and Ukrainian courts, or through the means of international criminal justice system, in particular, of course, of the International Criminal Court, which of course bears the primary responsibility for the investigation of alleged international crimes, in particular the named war crimes, crimes against humanity, and crime of genocide committed in the territory of Ukraine. But we also should consider and should understand that we need to have a comprehensive system of accountability. And this comprehensive system of accountability means that we need to have all the levels and all the layers of accountability filled with particular instruments and mechanisms, and that we cannot have a situation where there is a category of persons who, for instance, face impunity and who are not brought to responsibility. We quite often hear from our colleagues, lawyers from other states, for instance, that we should effectively and actively use all the existing international legal mechanisms and tools to bring Russia and Russian citizens to responsibility. We are answering to this that actually since 2014, within the strategy of lawfare against the Russian Federation, Ukraine does actively and effectively use each and every possible international mechanism, instrument, and tool to bring Russia and Russian citizens to responsibility. We have made applications to each and every possible international court or tribunal where we could file these applications. International Court of Justice, European Court of Human Rights, International Tribunal for the Law of the Sea, tribunals under the United Nations Convention on the Law of the Sea, Permanent Court of Arbitration, recognition of jurisdiction of the ICC, International Criminal Court. So we are already in all these processes. Everything which is established, everything which is now possible, we are there. But we do see that there are at least two gaps, at least two loopholes, which need to be filled for us to be able to say that comprehensive accountability really might take place and justice may prevail. These two gaps and loopholes are, first, international compensation mechanism for the compensation and remuneration of damages caused by the Russian aggression to Ukraine. And you know that just recently, 2 days ago, on the 14th of November, the United Nations General Assembly adopted a relevant resolution supporting the establishment of such an international compensation mechanism and international register of damage as a first step of establishing such a mechanism. And also the Special Tribunal for the Crime of Aggression against Ukraine, which again is very much needed when we talk about responsibility for the crime of aggression against our state. So why do we say that the crime of aggression against Ukraine and the Special Tribunal for this crime of aggression against Ukraine is something which need to be established, and this responsibility for the crime of aggression against Ukraine shall be secured? First of all, we do see that the crime of aggression is a crime under international law, which can bring us directly to those who are on top of the tree. So to those persons who are in charge of giving the relevant instructions to wage this aggressive war since 2014. So we see that this crime can lead us directly to top political leadership of the Russian Federation. Second, crime of aggression itself is rather easy to prove, in particular with all those facts which are available today about the Russian aggression against Ukraine, and all those resolutions adopted by many international organizations, in particular by the United Nations General Assembly. So this is a very good background to work on the crime of aggression, because the aggression of the Russian Federation against Ukraine is something very well settled in the international framework, in particular by states, our international partners, and international organizations. Third, there really might be some issues, in particular time-consuming issues, whenever one tries to establish the linkage of a particular war crime committed in Bucha, Irpin, Izum, Kupiansk, any other place which is liberated now in Ukraine, and the direct orders from the Kremlin. This linkage really is rather hard to prove. It may take years to establish it, and with no surety that the result might be there. And we also shall take into account as also an argument that the crime of aggression is a crime which gives rise to all the other mass atrocity crimes. It is the supreme international crime because it accumulates the accumulated evil of the whole. And we do understand that the last time in history of international criminal justice, when the perpetrators of the crime of aggression were brought to responsibility on international level, these were the cases of international military tribunals in Nuremberg and Tokyo. And since we are saying today, and we are of course sure of that the aggression of the Russian Federation against Ukraine is the biggest war in Europe since 1945, this is the right moment to work on investigation and prosecution of the crime of aggression against Ukraine. Moreover, since the issue of crime of aggression is really quite sensitive for international law, and this may be seen, for instance, within the framework of how the International Criminal Court got jurisdiction over the crime of aggression, how I would say, not easy the negotiations on the Kampala amendments were moving through. I think it is quite obvious that if the crime of aggression is not investigated and prosecuted this time, the crime of aggression might remain paper tiger, which will be included in textbooks on international criminal law and public international law, which will remain in speeches of experts, academics, politicians, but which will never be enforced on the international level. I'm sure that this is something what the international community should not let happen. And we all together shall work for the accountability for the crime of aggression to take place. So speaking about the nature of the crime of aggression and why it is important to work with this crime now to investigate and prosecute it, we also see, on the other hand, that currently we do not have the relevant and appropriate international mechanism to bring to responsibility perpetrators of the crime of aggression against Ukraine. By saying this, we mean that the International Criminal Court does not have and will not have jurisdiction to investigate and prosecute for the crime of aggression against Ukraine. It is because of the fact that the jurisdiction of the International Criminal Court in relation to the crime of aggression differs from the jurisdiction of the ICC in relation to 3 other international crimes: war crimes, crimes against humanity, and crime of genocide, and that it is rather limited. For instance, in order for the ICC to have jurisdiction over the crime of aggression against Ukraine, both states which are in the situation of armed conflict should have ratified the Rome Statute and the Kampala amendments on the crime of aggression to the Rome Statute, or the situation should be recognized as an act of aggression by the resolution of the United Nations Security Council, and the United Nations Security Council should refer the situation to the International Criminal Court. I'm sure that all of us here in Kiev, Berlin, New York, wherever, understand that neither of these prerequisites will be satisfied. This is quite obvious. So it means that the International Criminal Court will not be able to investigate and adjudicate this crime. It is also quite obvious that the national courts of Ukraine or of any other state cannot also adjudicate the cases concerning the crime of aggression in relation to the highest political leadership of the Russian Federation due to their immunities from foreign criminal jurisdiction of foreign states. This is a general rule of international law, that at least persons who represent the so-called troika, head of state, head of government, and minister of foreign affairs of a state, they do have immunity from foreign criminal jurisdiction of foreign states. So having said this, there might be really the situation when some middle-level Russian soldiers, officers, Russian military troops will be brought to responsibility for war crimes, crimes against humanity, other war-related crimes in Ukraine, in other domestic jurisdictions, because we know that many, in particular European states, opened investigation in relation to the situation in Ukraine, or by the International Criminal Court, but the top political leadership of the Russian Federation, who do not take direct participation in hostilities, who sit in high palaces in Moscow, they will stay impune. So they will have impunity because it will be very hard to establish the linkage of their orders, instructions, and the particular war crimes committed in Ukraine. So that is why we do believe that there is no other way to secure accountability and justice other than ensuring and securing the accountability for the crime of aggression against Ukraine. This crime of aggression should not be left without proper legal response. And when do we see and when do we say that this crime of aggression should not be left without proper response? We need to think how this may be done. And then we elaborate that we need to establish a new mechanism for this responsibility, because any of the currently existing mechanisms are not available for that. And that is why we are saying that the special tribunal for investigation and prosecution of the crime of aggression against Ukraine is the mechanism which may be very effective and active in order to bring representatives of the highest top Russian political and military leadership to responsibility for the crime of aggression. There are different options how this special tribunal may be established, either on the basis of agreement of Ukraine and the United Nations, having before and after, or after the resolution of UN General Assembly supporting this agreement, or on the basis of a multilateral treaty between states, between Ukraine and some particular number of other states, on the basis of agreement of Ukraine and European regional international organizations, say EU and or Council of Europe. So all the possibilities are there and all the options are open, and all the options may secure and may be effective for establishing of such a special tribunal. We are very open to discussing and considering which option might be the best one in this relation. But no matter which option may be chosen by us, by our international partners, we do understand and we do feel that currently there is no alternative to setting the special tribunal for the crime of aggression against Ukraine. That the crime of aggression against Ukraine may not and shall not and must not be left without proper legal response. If there will be impunity for the crime of aggression this time, this might lead really to the situation where any day, any time, any, I would say, dictator or ruler of any country of the world might consider that since the Russian aggression against Ukraine was left unpunished, she or he can do the same stuff in his or her region or in his or her country against its neighbor. And I'm sure that international criminal justice should not let these things happen. And I'm sure that responsibility for the war crimes and crimes against humanity in such an open case of aggression, in such an open, and I would say it is understood to everybody that this is the aggression of one state against another, that this is international armed conflict with all the relevant consequences. I'm sure that in such a situation, in such a case, it is not enough for us to speak about responsibility only for the war crimes, for the crimes against humanity, for genocide, but that we also must speak about responsibility for the crime of aggression against Ukraine and in this particular situation. So I would like to finish with saying that civil society, expert community, international expert community might really play a very important role by promoting and facilitating and fostering the idea of the need to secure accountability for the crime of aggression against Ukraine and the need to establish the special tribunal for the crime of aggression against Ukraine to fight impunity on the highest possible political level. So that is why if the participants of today's event, if the organizations which are represented today in Berlin and Kyiv, in any other places which join online, can consider promoting and facilitating this idea of the establishment of the special tribunal and the need to secure accountability for the crime of aggression against Ukraine, I'm sure that this would be an important input to our common goal, which is justice, security, accountability, and peace. Peace without justice, I'm sure, cannot be reached. I thank you for your attention.
Дякую, Антоне. Дякую за ті
Thank you, Anton. Thank you for your important topics that you were talking about and the problems that are still in front of us, that we had a possibility to talk about this. Also, thank you very much that you found the time, also within the time difference between Berlin and New York, and that you could join our meeting. And now, we have our format slightly short because we started a little bit later. So I suggest now like to that Anton will leave our session. So, and if someone wants to ask Anton something, please, yeah, Anton, maybe you can answer 2 questions or so, and then we will proceed with our discussions. I see your consent. Thank you very much. Thank you, Anton, for your speech. I am Yuriy Belousov. I am a lawyer and from the organization FIDH. Are there some mechanism about the negotiation in order to build this tribunal? Are there some negotiations? Is the process started already? Thank you. Thank you for your questions. I have a technical questions. Is it better for me to answer in English or Ukrainian?
In English, sure. It's just a technical issue for participants to feel comfortable in this situation. So thank you, Ilya, for your question. It is an important one. I would say that since the beginning of the full-scale invasion of the Russian Federation to Ukraine on the 24th of February this year, the work on the establishment of this special tribunal has started. And as of now, I may say that we do have good political results in getting political support to the idea and concept of establishing of the special tribunal. For instance, we do already have 3 resolutions of the Parliamentary Assembly of the Council of Europe, 3 resolutions of the European Parliament, declaration of Parliamentary Assembly of NATO, resolution of Parliamentary Assembly of OSCE, several resolutions of national parliaments, in particular Ukraine, Lithuania, Estonia, Netherlands, which do call for the establishment of the special tribunal as a needed instrument to bring justice to this particular situation. There is also a motion for resolution in German Bundestag filed recently with also the call for support from the Bundestag towards the idea of the establishment of the special tribunal. We are now also trying to test the ground within the United Nations system. How can we move forward, in particular in relation to have a resolution of the United Nations General Assembly dealing with accountability, dealing for all the international crimes committed in the territory of Ukraine, but of course, in particular, also paying particular attention to the issue of the crime of aggression against Ukraine. We also gathered a group of like-minded states, which together with Ukraine are really wanting to facilitate and foster this process inside international organizations or different other formats. There are also important conclusions of the European Council of the European Union of 20th and 21st of October, which instruct the European Commission and the European External Action Services to discover the options to secure the full accountability for all the crimes which were and are committed in and against Ukraine, in particular also the crime of aggression. So yes, there is already a very important background, both political and legal, in relation to the establishment of the special tribunal. And now we are on a very important stage of, I would say, transforming or moving from the political support to some particular and concrete legal and technical steps. So that is where we are now. And so just to say that, yes, we are not doing this from nothing. We already have a relevant and appropriate background, which is important for us to move forward.
Дякую. Наступне запитання.
Thank you. Next question.
For democratic institutions and human rights. Thank you, Mr. Korynevych, for a very compelling argument for investigating and prosecuting the crime of aggression. What I wanted to ask maybe builds up on what you were saying so far. Are there talks with, at the MFA or among the partners about any deficiencies of a possibility of establishing this court through a multilateral treaty with a number of, let's say, supportive states. I'm from a region that had an international tribunal that was set up with United Nations Security Council resolution, and that was a strong path to go forward. So I'm thinking, is there this line of thinking that a multilateral treaty or going through like EU or some other organization might be less effective or seen as less independent? Thank you.
Thank you for your question. Of course, we do understand that the most legitimate and credible way is to move through the United Nations system. But we also understand that the United Nations Security Council cannot be used in this situation because of the Russian veto in the Security Council. We do consider the possibility of using the machinery of the United Nations General Assembly in the situation when United Nations Security Council cannot do its job. But in general, we all must understand that the role of the Russian Federation inside the United Nations is something which must be taken into account. So we are, as I said, now discovering all the options, and in particular the option of the United Nations. So nobody is leaving behind the attention any of the possibilities, any of the options. And of course, from legal point of view, we do understand all the legal challenges which might occur. But I want to stress one issue which Mr. Oleksandr Pavlichenko was speaking when he had the floor. Whenever there is a political will and the political understanding from the leadership of states that this should be done, I'm more than sure that all the legal challenges can be worked out. Whenever understanding that legal challenges is something which is really important and shall be taken into account, we must also understand that the main issue is getting political will from the leadership, from the key stakeholders, key decision makers, to move forward on this path.
Дякую. І ще одне питання.
Thank you very much. One last question. Excuse me that we can't take all into account.
Anton, you also have been to the conference on genocide here in Berlin, and German professors proposed that it would be necessary to have maybe not a fully new special tribunal, but a special tribunal which is connected to already existing international judiciary. For example, as an expansion of ICC, yes, to have, as you said, a contract with United Nations, a decision of General Assembly, and maybe also a cooperative agreement with ICC between the new tribunal and the ICC. So how do you see that way of possibility? And the second question is, as you know, the concerns of the partners of Ukraine, like Germany, they do not want to see the existing international judiciary being weakened. So what is your opinion, for example? Is it realistic to expect that Ukraine, for example, will adopt the Rome Statute when there is a real perspective to have a special tribunal? So to do both in order to give the signal, Ukraine knows it has its own responsibility and we fully commit to all aspects of international judiciary. Thank you so much.
Thank you, Wilfred, for your questions. It's a pleasure to see you here, also online. Concerning your first question, we do consider that this special tribunal, whichever option will be chosen for its establishment, will be a complementary and supplementary to the current international criminal justice system, in particular to the International Criminal Court. So we do not want to create or establish some alternative mechanism or practices. It is not our job. It is not our goal. We do want to establish a tribunal which will work on only one particular crime of aggression, because this is a crime which is in the jurisdiction of the ICC, but ICC in this particular situation cannot work with it. So we do envisage that the special tribunal itself must be established on the basis of the approaches and standards and principles which are set forth in the Rome Statute of the International Criminal Court. So yes, we do believe that this complementarity and supplementarity of the special tribunal to the International Criminal Court is very important. And also mixing the, trying to mix the answers to the first and second questions of Wilfred, we of course do believe in the primary role of the International Criminal Court. So as you know, Ukraine recognized jurisdiction of the International Criminal Court. Ukraine's law enforcement agencies and prosecutors' offices do have active and effective cooperation with the International Criminal Court on the daily basis. Ukraine's leadership do have communication with the leadership of the International Criminal Court. Ukrainian Parliament, Verkhovna Rada, has recently adopted several laws which are important for the effectiveness of the work of the ICC in Ukraine. In particular, concerning the separate chapter of the Criminal Procedural Code of Ukraine, which is about cooperation of Ukraine and the International Criminal Court. So I do believe personally, and I am personally a big fan of the International Criminal Court. Historically and legally, I do think that the ICC is very important. So I do believe that ICC now does have all the necessary machinery and instruments for it to be effective concerning the situation in Ukraine. And I think that the ICC itself may be really satisfied with the level of cooperation which exists nowadays. Concerning the ratification of the Rome Statute, I'm sure that one day this will happen. So I do not see any contradictions or any legal or political challenges towards this issue. But as of now, ICC does have everything for it to be effective and active over the situation in Ukraine. And I'm sure that it is also about the, approach of the ICC that I'm sure that colleagues who work there understand that they should show result concerning the situation in Ukraine. And we will, of course, be more than happy with active work of the International Criminal Court in its investigation of the situation in Ukraine.
Дякую, Антоне.
Thank you, Anton. Thank you again for your participation in our session, and thank you for getting up middle in the night and talk to us. For us, is very important how you see the position of Ukraine. So we go on with the discussion, and I wish you good night, I think. Thank you. So dear friends and colleagues, I suggest that we go on in our session, and I ask, is Yuriy Belousov now with us online? No, unfortunately, no. Our member of the Prosecutor General's Office of Ukraine, he couldn't join us today. We know. We also know how much work our prosecutor have, and also the Prosecutor General's Office of Ukraine have. So I am sorry that we don't have a possibility today to talk to Yuriy Belousov. Then I suggest that Sergiy will talk to us, the International Organization of the Human Rights. He is also from the University Science 4. So the floor is yours. Please give us your vision on international problems in this international court, and what is your opinion as a protector of human rights and as a person who can see alternatives
Thank you very much. Thank you for the organizers for giving me the floor, and good morning, everyone. I represent the International Federation for Human Rights. We're a member-based, non-governmental organization based in Paris. We federate 192 member non-governmental organizations around the world, And in Ukraine, our members are Center for Civil Liberties and the Kharkov Human Rights Protection Group. We've been working on the Ukrainian war since 2014, namely in the documentation of violations with a focus on sexual and gender-based violence, and more recently on forced deportations. We have done build cases with a view towards prosecutions on the basis of universal jurisdiction national courts or on the basis of other forms of jurisdictions. We've submitted communications to the International Criminal Court for alleged violations committed in non-government controlled territories. And we have done a lot of advocacy, and that kind of brings me to the point raised by Mr. Korynevych, the calls for organizations to support initiatives such as the establishment of the Special Court for Aggression. And I must begin with a confession that we have not taken a firm position with respect to this call. Frankly, we have disagreements within the organization on whether this is something that is the most desirable from the standpoint of victims, because we work with NGOs that work directly with victims, and our activities and demands are always driven by organizations that work directly on the ground. So there's been some debate internally as to what we should and shouldn't be supporting. So I'd like to speak about some of the different avenues of accountability, and perhaps not to rehash what has been said already, but to offer maybe some food for thought, some alternative accountability mechanisms that haven't received so much attention, and also to maybe make some critical remarks with respect to the calls for the establishment of the special tribunal for aggression. And I must say here that I'm not speaking in this respect on behalf of my organization. These are my views, and they don't represent the views of FIDH. So I should like to say at the beginning that I think that the current context is a time of great opportunity for international criminal law. Unfortunately, it is because it's a context of great turmoil and conflict. And this is when in the history of international criminal law we have had the greatest impulse to innovate, to establish international tribunals and other accountability mechanisms. And such as the time now, we see that there's been a great political will to advance accountability with respect to Russia's crimes committed in Ukraine. We've had a record number of ICC referrals, creation of atrocity advisory group, Eurojust investigation, joint mobile teams, the excellent documentation efforts that are taking place on the ground, numerous domestic investigations. So why do we need more? Why do we need more? It's a reasonable question to ask, and one obvious answer is what Mr. Korynevych, Ms. Mezentseva, and others have said. It's the lack of jurisdiction currently by an international court, I should say, over the crime of aggression, because domestically there is jurisdiction over the crime of aggression under Ukrainian penal code. And I think the other, which hasn't been spoken so much about, the other need is due to the lack of capacity, frankly, to work through 45,000 or 62,000. I'm now a little bit confused with respect to the numbers because we've heard different figures through these 2 days. It seems at least that over 45,000 cases have been registered so far, and no domestic judicial system is capable of working through such a great number of criminal cases. So I do believe that we have a need for something else. Because national courts are not well equipped to handle all of those cases. The cases that are brought on the basis of what's called universal jurisdiction, so without any linkage to the place of the perpetration of the crime and the state where the case is being investigated. There are 18 states currently that are bringing such cases, but in the end, they will end up in only a couple of dozen prosecutions. I should also say here that sometimes universal jurisdiction is a misnomer, actually, because in France, where FIDH is based, the 7 cases that have been opened so far by the prosecutorial authorities are on the basis of passive nationality jurisdiction, which means that the French nationals were hurt or killed as a consequence of acts of Russian perpetrators in Ukraine. So this is not; these are not universal jurisdiction cases. But that also means that we should explore these alternative forms of jurisdiction in national courts outside of Ukraine on the basis of passive but also active nationality jurisdictions. Not many know, but my organization a few years ago has brought a complaint to the French authorities denouncing French mercenaries that fought on the side of pro-Russia separatists in the so-called Donetsk and Luhansk People's Republics. So there you see an example of the use of active nationality jurisdiction in national courts outside of Ukraine. And I submit to you, there are now citizens of other countries, for example, from Central Asia, that are fighting on behalf of the Russian formations, armed formations. So we should explore not only Western European states, but also other states that might have jurisdiction over those nationals or over those crimes. But then again, like I said, that will end up in another handful of prosecutions, and that's why it's great that there is the International Criminal Court, which, when all is said and done, will likely also bring a handful of prosecutions if other situations are a precedent to look to see what the court is likely to do. We just saw the situation in Georgia come to a culmination in a disappointing result of 2 prosecutions, and what we hope to be subsequent prosecutions, and it's unlikely that more will materialize. And so I do believe that there should be an establishment of something of a hybrid court for Ukraine. Now, I don't believe that the court for the crime of aggression alone is sufficient, and my biggest concern is that narrow subject matter jurisdiction. I think that a court that could be established should have a broader jurisdiction, which will cover the crime of aggression, but also other international crimes that the national justice system will just be unable to process by itself. This type of a court could be embedded within the domestic system, like the Kosovo Special Chambers, for instance, or it could be a hybrid international court formed as a consequence of an agreement between the United States and Ukraine. Ideally, it would be by the United Nations and Ukraine, or maybe the European Union and Ukraine. There has been a precedent of an international criminal court and a hybrid court operating together along with the national courts, so sort of accountability on 3 levels. In Central African Republic, we have this taking place as we speak. Granted, the national judicial system is not as robust in Central African Republic as it is in Ukraine, but then again, the number of cases in Central African Republic is much smaller. But there you have the ICC, which has jurisdiction, and also there was a special court for Central African Republic, special criminal court that has been created, which just the other day handed down its first 2 convictions for crimes against humanity. So it is possible. These jurisdictions may work on a complementary basis. And I have some other reasons, justifications for the establishment of such an institution and sort of critiques of the hybrid court for aggression. Well, first of all, this is kind of just a personal remark. I never really quite understood why aggression is considered the supreme crime of them all. I will remind the members of the audience that aggression only exists in international armed conflicts. Granted, this is what we have here, so it's very much applicable, but in Syria, there was no crime of aggression, right? And nevertheless, we have all these other international crimes that are taking place. So it's not that you have aggression that all these other crimes follow necessarily. It's not that it's supreme crime just because temporally it is first in the sequence of other crimes that then take place. But anyway, you might disagree with that. I believe that a hybrid court with a broader jurisdiction might have a greater legitimacy in the eyes of the victims. Why do I say that? I think it's also due to the special nature of the crime of aggression. Crime of aggression is a crime that targets states. It's not a crime that targets individuals. And as a consequence, to prove the crime of aggression, you might not have as many victims. You might have some that will testify as to, in order to establish the guilt of the accused. Most of the evidence will be gleaned, could be gleaned from open sources or those that are closest to the highest echelons of power. So the victims are not going to have a stage, and this is a major problem in my view. And sort of a side note to that is I wonder how much the victim communities and the NGOs that we work with, for instance, have been consulted before getting behind this idea of the establishment of the special court for aggression. Ultimately, the judgment passed down by this court will be made in absentia. I think we all agree that it will be very difficult to get our hands on Putin, Lukashenko, and the others. And this, again, is the problem of legitimacy and ultimate feeling of justice for the victims. How will victims of torture, rape, forced abductions, arbitrary detentions feel about a conviction in absentia of a highly placed official? I think symbolically it is still a very strong act. Nevertheless, I think it's far from bringing justice to all those thousands and hundreds of thousands, maybe millions of victims that have suffered as a consequence of Russia's actions, violations of international humanitarian law and human rights law. But frankly, by virtue of having a broader mandate, the court, which will include aggression and the other international crimes, will thus cast the net wider and, frankly, end up hopefully convicting a greater number of perpetrators. And one thing that hasn't been touched on at all, I think that with a hybrid court, with a broader jurisdiction, there's a chance to bring more innovation. And I'm referring here to including more progressive forms of jurisdiction, such as jurisdiction over legal entities. And this is very controversial, of course. The last time we had an organization that was indicted for international crimes was during Nuremberg. Since that time, international justice does not regard legal entities as subjects of international law for the purpose of imposition of criminal responsibility. And I think it's high time to change that. Just a few years ago, there was a judgment by the Special Tribunal for Lebanon, which judged a corporation to be guilty of a crime, albeit a crime of contempt, not of an international crime. But an argument has been made that the corporate criminal liability has become something close to a general principle of international law. So including legal entities such as corporations, why not Gazprom, put Gazprom on the stand, is something that I think could be desirable in such a context, and such an option could only be possible with the establishment of a broader mandate for a special criminal court. And I'll conclude by saying, referring to some other accountability mechanisms that are not courts stricto sensu, but nevertheless they touch on aspects of accountability. I'm a transitional justice practitioner, so I always say that we shouldn't just think about prosecutions as the panacea, right? It's not the only thing that victims of crimes care about, and these are not the only demands. There's a great demand for reparations, for rehabilitation, physical, psychological. We should keep these things in mind. One thing though, as far as documentation and preservation of evidence, now there's a great discussion taking place regarding the establishment of something of a permanent international impartial independent mechanism within the UN for the preservation of evidence, which akin to the IIIM for Syria, right? And I think with the abundance of the evidence that keeps coming in, it would be good to have one common repository which preserves and archives this evidence for future use in criminal prosecutions. And again, to not obsess over prosecutions, I'd like to echo what Mr. Korynevych has said with respect to the recent resolution on reparations, establishing the basis for reparations for Russia. I think it's a very important step and a good step forward towards fulfilling those other demands of victims of these crimes, not only accountability, but also compensation for the losses they suffered and physical and psychological rehabilitation. Thank you very much.
Дякую. Дякую, пане Ілля. Ви підняли досить
Thank you so much. You have brought up the very important points about that nothing is ideal and everything has flaws and nuances that we have to take into consideration when we try to choose the system of how we will do it. And of course, it is impossible only with one level of jurisdiction to bring everybody to justice. And this principle of universal jurisdiction is a very complex one. And I would like to continue with the following. All our speakers have spoken today about the tribunal, the special tribunal, special court, reparations, remunerations, but it is all impossible without us documenting all the crimes, all the infrastructure that has been destroyed, all the lives that have been lost that we have today. And without this documenting and documentation, we cannot go further. And here I must introduce myself. I am a member of Ukrainian Helsinki Human Rights Union, and I am documenting war crimes, and I work with the victims of this war since 2014. And we have our initiative T4P, Tribunal for Putin, and we are immediately documenting war crimes as soon as possible. And this year has been, of course, the worst, and we have so much work ahead. 1 month is 1 month that Bucha was occupied. And what have we seen afterwards? So what will we see when Donetsk, Luhansk, Sevastopol would be de-occupied? This occupation has lasted for 9 years. So how difficult it would be to document, to find all the facts. It's a very long process. It's hard. It's not easy to bear, to document this, to work with this information. And I can give you some examples of how we work. Oleksandr Pavlichenko has spoken about the examples since 2014. I can bring you the newest cases. This is the woman who was on the street occasionally when the Russian troops were just passing by, and they just shot her in the head. She was no threat for them. She was not military. She was no threat whatsoever. She was just on the street. We have a story from the district of Kiev on a mother who was forced to bury her daughter 4 times. She was killed when this city or village was shelled, and they didn't give her the opportunity to bury her child. And we have also a woman who must live for the rest of her life with a split of 1 shell of munition in her spine, and it's impossible to remove because it is stuck 2 millimeters from the very, very important arteries, and it cannot be removed without killing her. And this is just one. These are just few of examples. When the people are deprived of the right to bury, dignifully bury their dead, they were forced to keep their dead in their flat without a possibility to cool it down. And they could bury them month and month after they've been killed. And we have to name every crime. We have to name every victim, and every perpetrator must have a name, must be identified. Every dead and killed person has to be identified, and every perpetrator must bring them to justice. And we are not even speaking of the destruction the damage that has been done, and we must speak of it, because when we are speaking of reparations and remunerations, of course, these international mechanisms of bringing to justice, they are so important, and we are talking about it constantly. But when we see what is going on in Ukraine, we cannot forget that everything, we must not, that we have done everything. No, we must do more, even more, because every case must be documented. Because if we allow for the Russian war criminals to stay impune, so what is every international mechanism or court worth in the end if somebody remains impune, if Russian criminals are not punished, they just understand that they can do it again and again. Not to Ukraine, but maybe to some other country. That Russia has borders with Baltic states. They are smaller states. What can stop them in the future, if we don't do it now, if they decide someday maybe we can occupy them? When we think back about the 1930s, maybe they want to occupy Finland. They tried it in the past. And after our victory, after Ukrainian victory, we must punish them. If we don't do that, so that would be a signal to the rest of the countries that such crimes can be committed and there is no punishment. And we must show that the system, the existing system of justice is there and is working. And we have to show it now that the international community is unified and that it can help us, and it must help us to bring everybody to justice. And this is, I've come to the end of my speech, and please, if you have questions,
Question for each speaker who are here now, if it's okay. They are very short questions, and first one is for Pan Oleksandr. It's kind of like a provocative question, I guess, but I think if we don't ask ourselves these questions, then Russians will ask us these questions, and it's how to assure a fair trial for Russian criminals in Ukraine, and how to assure that Ukrainian courts are both independent and impartial, because we all understand that there is no single person who has not been affected by the war. And I know it's a very complicated question, but I would be very thankful for your expert opinion. And I will ask, if that's okay, I will also ask questions to everyone else. Sorry?
It works well.
Oh, sorry. For Mr. Ilya Nuzov. Oh, yeah.
Okay, very brief answer. Well, this question was raised up when we've stayed in ICC in The Hague, and we discussed it separately as a separate issue. Yes, the answer is that the level of judiciary and the characteristics of judiciary is the impartiality and independence, and now we see that sometimes we have the questions towards some judicial verdicts. But I think that for the future processes and for the ongoing processes, we should include the reasons that the judiciary as the notion and the let's say the branch of the power is not politic power, so it should be out of politics. And even if we may have this suspicion that the judiciary, as you've mentioned, represent the judges and all the judicial staff that might be, let's say, partly the victims of this war and conflict since 2014, but impartiality, is one of the one of the main characteristics, independence as well. And furthermore, Ukraine is also in the system of the ECHR, and the verdicts that violate the rules of European Convention and Article 5, Article 6, well, are deeply related, for example, for these issues, might be reconsidered by the other institutions, and still it's the standards and indicators that we have the values that keep us stronger than the suspicion that our judiciary might be affectable by these, let's say, alleged factors. So the brief answer is, yes, we stay on other values that doesn't allow us to be weak in judiciary.
Thank you very much. A very short question also for Mr. Nuzov, if that's okay. You were talking about how in the crime of aggression, it's a crime against state. And I'm wondering if, despite that, certain victims and survivors could be part of the process, including, for example, Ukrainian soldiers, who are per se legitimate targets, according to IHL. But I feel like within the framework of the crime of aggression, they could still be victims and survivors of the crime of aggression, unlike in the IHL framework. What do you think about that? Thank you.
I think you're right. So the short answer is I think you're right. I think that a very limited number of military staff that had personal knowledge of orders that would end up constituting the commission, what are one of the elements of the crime of aggression, could be called up to testify. And I don't recall, I'm fairly certain that with respect to the crime of aggression during the Nuremberg trial, there were one or two witnesses that were presented, but I think it was mostly a show process to couch the crime of aggression in a broader context. So there were witnesses that would speak to the broader context, political context at the prevailing at the time. But I'm referring to the victims who are, of course, non-military, who have suffered direct violations of international human rights and humanitarian laws, such as victims of, extrajudicial executions and arbitrary arrests, deportations, and so on and so forth. None of those would be pertinent, I believe, to the crime of aggression.
Дякую. Передаю під наступне питання. Єдине, що я прошу відмітити, що в нас залишилося
We have one last question because we have only 7 minutes left now.
Thank you very much. Very interesting session. I would like to say that it is important to adopt a victim-focused approach towards accountability. And when we hear that there are tens of thousands of cases, then the real question for me is how to deal as effectively as possible with this large amount of cases, and how to provide justice to the victims as quickly, as effectively as possible. And in that context, while not being against the idea of a special tribunal, my feeling is that too much time is devoted to this academic discussion and political discussion, and not enough time is devoted to what is up here, namely how to optimize the documentation of war crimes, how to coordinate the efforts of civil society, how to get international assistance, for example, through the genocide network of the European Union and other national jurisdictions who have been asked to provide assistance. How many such prosecutors, for example, have come from other countries to support the Ukrainian efforts? and so on. So I think these are the burning issues at the moment, how to achieve a proper documentation which can then also work before the courts. Because it's quite a difference whether you document in a general way war crimes or whether you collect, and you know it best, the information in a way that it can be used in court, and so that there are successful cases. How many cases have been opened and are in court already? All these issues would be interesting. Whereas the question of the special tribunal is something which is much more long-term. For example, when you look at the proposed statute, it says that the trial has to take place in the presence of the person indicted. So when will you get put in there? When you really achieve that, then maybe things will have changed anyway. Okay.
It's not even the question, it's just appreciation of the situation and the wish to strengthen the national or existing instruments. And I totally agree with that was said by you, and may just tell that among these 20, well, no, not 20, it was 48, 46,000, almost 47,000 registered cases. Only dozen cases are in judicial proceedings, and till now we have, well, as to the end of September, it was 14 verdicts adopted by the courts. Taking into account the character of judiciary in Ukraine, it was, well, with the speed, fast process, because normal criminal proceedings take 3, 5, 7, even 10 years with all the levels. But to have in several months, 2-3 months, and you have the verdict, it's something incredible. Still, we have such verdicts. Well, but I'm totally agree that the reorientation and the victim-focused approach should be the main target and goal, and be the focus for national and international mechanisms.
Я коротко додам, що
I would like to add also, I would like to ask that the best help for the documentation of war crimes is the freeing of the complete territory of Ukraine, so we can access all cities, all graves, and all victims who were victims of the war crimes. And then we need the help of prosecutors and so on. Now we need help to free the...
It's very hard to disagree with Professor Benedict. And I do believe that the emphasis right now should be on documentation, but I think Professor Benedict also kind of alluded to the problem of what then to do with all this documentation, because I think the documentation efforts are very significant. Just the Tribunal for Putin database contains over 24,000 instances of alleged violations committed, but then I do believe that probably over 80% of this information will never come to see the light of the courtroom, let's say. So documentation in and of itself does not bring accountability in the conventional sense. It does offer maybe some kind of a relief to victims, because by virtue of having spoken to someone and testified to somebody who's willing to listen to their story. So I think maybe the emphasis should be on producing now more of analytical materials and these and more personal stories that are widely accessible, available in different languages, of what the victims of these crimes are going through, how they're suffering, and then But I do believe that we need to think about the accountability, avenues of accountability that will cover as many perpetrators as possible. And I think we should also think about, well, what will happen on the Russian side. I think that eventually that regime will fall, and what will happen is a mass lustrations, which is something that I'm advocating for, which is also a form of accountability, a form of responsibility. And I think we should all start thinking about something of a truth commission, which is also another platform that gives the thousands, hundreds of, maybe hundreds of thousands of victims the opportunity to publicly testify about what they had suffered. And this also might offer some kind of a cathartic experience that will help victims to heal the trauma.
Дякую.
Yeah, thank you very much. I'm Andreas Schulhoff, ECCHR, also work on universal jurisdiction cases across Europe. And just 2 points to second what you've said. I think it's also quite important to think about building cases against high-level perpetrators. Often you need defectors or others who are leaving the armed forces now or in the coming years. I think under universal jurisdiction, also third states can play a role to secure their evidence and to provide them a safe space to give evidence against in the chain of command. And also a permanent UN mechanism, I think, deserves much more debate, because they could also fulfill that role that might be difficult for the ICC or also for the Ukrainian judiciary to do, and it's quite important pieces of evidence. So I think also in that aspect to discuss more how cases could be built, that's an important one. And also what you've said, Ilya, on the I think more debate is needed, which kind of mechanism, hybrid or however you would call it. There are many examples from the past 20 years globally to deal with the sheer amount of cases. Could be the most useful to have some results in 5 and 10 years to come from that perspective. Just the last comment on the special tribunal discussion. The Rome Statute of the ICC could be changed within months if enough states agree. So the reason why the crime of aggression has a different jurisdictional standards than the other crimes, it's based on a French and UK proposal in Kampala. So those were the states that prevented that there's equal application of the crime of aggression for other states. So, but the Rome Statute could be changed, and it could be applied retroactively also on the crime of aggression on Ukraine. But of course, you need state support, and it shows where powerful states have different interests in making that happen. So I think that's also something we need to talk about. Thank you very much.
Я просто откомментирую, что это очень правильно.
I want to comment it. Yes, it's the right approach, but to change something in wartime, it will be not be legitimate for something.
And I am already in the field for a couple of years working with many of the colleagues here, so thank you. I have a very practical thing to ask. So the cases that you document since 2014 and even maybe before, how do you include people who've been deported? I mean, is there a mechanism how you check those cases, how you track that, how, I mean, people being deported are not within the reach, even if you free a city, those people who are not there anymore, how you can be following up on them. I mean, I'm so worried about so many losses that Ukraine is suffering now. It's also like, you can't trade goods, like corn, grains are stolen, everything is being shifted away, like things are destructed and so on and so forth. There's so many things to consider, but what about the people who aren't there anymore?
Дякую за запитання.
Thank you for your question. Yes, it's the case. We have a problem with deportation of people, but one part of the people that we can return, these are children, the children who were deported forcibly to Russian Federation. We work directly with these people or also remote when they are still in the Russian Federation. They can connect to us or they leave Russian Federation later. The occupation of Ukraine, it's not only a way to find and to document all atrocities, because one part of people were deported to Russian Federation, and part of people left Ukraine on their own to Russian Federation. So this process will last few years, and it's a complicated process and has a lot of challenges indeed, but we are ready for this process.
We work together with the lawyer communities in different countries like Poland, like Lithuania and other, and they assist in this documenting, especially in Baltic states, when they receive the person that coming from Russia escaping from this deportation process. So it's partly also, let's say, not controlled, but documented by our legal partners and law enforcement structures, JITs, joint investigation teams that are established among the different countries with the aim to assist Ukraine to document and investigate such crimes. So we have the mechanism, but of course the strengthening of such mechanism and searching of all possible other means to document these crimes. And I may tell that we have also very specific position with international structures like UN, different monitoring missions, Red Cross. They are able to communicate and have access to some vulnerable persons and they victims of such war crimes, but they doesn't open this information. They just put it in their statistics. They have their files, but it's not even for national structures open. So it's also the issue to be discussed.
Sorry. Останнє питання. Last question.
Sorry, actually I had two, but okay. I just wanted to ask if you, in the course of your discussions, you have mentioned the other armed conflict caused by Russia. So Ilya told about Syria, but also I'm also thinking about Chechnya and about Georgia. So are those crimes either aggression, either crimes against humanity or war crimes, or now can be mentioned in a global framework of a special tribunal for Putin or for Russia? I don't know, but that would be able to also gather again those almost forgotten crimes?
Simple answer. A simplest way will be to construct this accountability mechanism, the most achievable it will be. So if we will adjust with other crimes, it will be more difficult. Same with genocide issue. So it's easier to go straight and to consider much more simple, let's say, international crimes like war crimes and crimes against humanity than to stress on genocide character of crimes. Well, yes, you understand. And if we complicate this issue, so we will have more difficult processes and we will be far from the achieved goal. Thanks.
Дякую всім за запитання. Дякую спікерам. Дякую вам, учасникам, за те, що ви обрали саме цю сесію, що ви прийшли,
Session that you came and that you took your time for this important topic. I want also to thank our technician support. They are today with us because during the session they did everything possible to correct all the failures of another aspects. So thank you, our technical support. I also want to say you that everything, our timetable is delayed by 30 minutes. So that's why the organizers said us, please, if you choose the sessions, please consider it. It's regarding the next steps. I wanted to say that every atrocity has a name and every victim has a name. And I want to say, if you choose which panel you yes, so you are at the right place, and we start our last panel at 3 p.m. and you can hear the story of the people who are the victims of war crimes, and they can tell you what happens and what Russian soldiers did. So that's why at 3 p.m. I think you should choose this room at 3 p.m. So I thank everyone. Thank you for being here.